Yes, Mr. Van Dijk.
May I please, my Lord, may I just start by making a quick clarification about a small point I made yesterday in relation to the sign for mark comparison. I was making a submission that this court could assume that my learned friend had effectively withdrawn that contention because he hadn't pursued it in his closing oral or written statements. While that's correct, what he did do is make a reference to it in his rejoinder submissions, which I don't really need to show you that.
I'm sorry, we've got some noise off stage, so could you just wait till the door's closed and we can hear you properly?
Of course, and I was going rather rapidly. So I made a submission yesterday that this court could be satisfied that effectively the issue about identicality has been withdrawn by my learned friend because he didn't address it substantively. And I made that submission on the basis he didn't address it in his closing oral submissions. That was correct. What I'd overlooked was that we had commercial court submissions. So he did closing submissions, I did responsive submissions, then he did brief reply submissions. So I need to show you what he said. It's not much, but I need to show you what he said in his reply submissions in relation to this one point. So it's an SB1 behind tab 37, page 335, manuscript page 891, top of the page, sorry, manuscript 891, top left-hand corner of the authorities of the bundle, page 335, and at line 2, Mr. Malinich in reply is saying, infringement, we say this. My learned friend says I should have dealt with it much longer. He himself dealt with it in 5 minutes. The reason it's not been dealt with is because it's very simple. Whoever has the earlier right, there is going to be infringement. No one would seriously mention that the additional subtraction of S makes any difference. That's why this case is arguably a case for identical mark, identical services. We mentioned IBM and WebSphere case in our opening. With the case law in the Court of Justice, it's a little bit woolly on identical. Identical means not quite identical. Small differences simply would not be noticed. During the hearing, you probably noticed there's occasional dropping of S's. People cannot quite remember which one is which. It's arguably identical. There's no need for likelihood of confusion. There's a need for likelihood of confusion. It goes without saying it's obviously likelihood of confusion. So I can't say that he formally abandoned the point by omission. It was still there. But I do say...
Well, on the contrary, surely you must accept in the light of that he was positively advancing the case, albeit it might be said in slightly tentative terms.
I would... Sometimes it said a light touch. That was probably the lightest touch he could possibly give to that point, but it was a point that was there. So I do accept. The judge did not formally address it in terms of the reason. She came to a conclusion, and so my secondary submission in relation to that, the one which I gave to you yesterday afternoon, was that insofar as it was an issue, the judge has applied the correct test to come to the right answer. If my lords feel that she didn't give any reason, which is absolutely correct in relation to that, and they feel that's an error of principle, then what I invite my lords to do is address that, applying the right law, and you come to exactly the same conclusion, so that it is not material to this appeal. Thank you very much, Lord. Now, yesterday evening, I got to the stage where I was showing my lords the material which the judge was perfectly entitled to find, and did find that the nuclei use of EasyOffices in relation to its website was portal use, and that was understood by both nuclei themselves, but also by third parties, including, amongst others, EasyGroup themselves, and in the publication I showed you, third-party publication of the British Location Review, amongst others. Now, consistent with that is the distinction which EasyGroup themselves applied at all times to a brokerage service as opposed to a rental of office service. It's a distinction which they themselves used throughout this case, and they used it specifically in relation to dealing with the non-use allegation themselves. And I want to show you, if I can, part 18, further information response, which they gave in relation to use, in relation to this, just to make good that point, that they themselves were consistently drawing a distinction between the two different types of use. And secondly, as a foreshadowing of what I'm going to go on to do today, which is address the revocation point. So could I ask you to take core bundle, please, and turn to tab 33. and turn to page 372, please. And the request 2 there, insofar as the claimant will advance a case of genuine use, please explain the claimant's case concerning the time period or periods within which relevant market data have been put to genuine use. And then you have the response this is given by EasyGroup over the next 3 pages, and they group it by reference to different time periods. The relevant time period for us is the period 2010 through to 2019, which you'll see on page 374. And you'll see the answer there is that from 2010 onwards, the EasyOffice business was operated by the claimant who continued to use the registered EasyOffice marks and continued to operate the EasyOffice business on the following different levels. Firstly, operating serviced offices. Secondly, brokerage of serviced offices via the easyoffice.co.uk website using data provided on a white label basis by Instant Office Limited. And 3, offering and managing franchisees of EasyOffice business. If my Lord could just read then down to the bottom of that section as well. And while we're there, I would also ask my Lord to look at request 4.
Right, but these are said to be different levels.
Yes, different levels. But it's not
Where do you say that they admit that these are different services?
I don't say they admit, I say it's consistent with they themselves using a separation of service type, business type, to describe the nature of the use which they're using. It's not an admission, I'm not saying it's an admission, it's pleading that they are saying that those 2 different service types are clearly, one's falling within rental of office, serviced office, or one is information advisory. And I'd say it's entirely consistent with that. What they do, what they are saying by this, my abstract submission, is that they are saying these are 2 different types of business. In fact, they're identifying 3 different types of business going on here. One is...
Well, why so? Because we can see from the website that they're advertised in parallel, one next to the other. So they're acknowledging that under the bonnet, as it were, there's different things going on, because in relation to Croydon, to take a material example, it's their own offices, whereas in relation to others, the offices are provided by third parties.
Well,
but so there is plainly a factual distinction which they are acknowledging.
Yes.
But where does this go to in terms of it being a different service and perceived as such by the average consumer?
Well, because, my Lord, what I'm saying is they themselves here are identifying that operating serviced offices is a type of business. That is, we say, as a submission, the rental of office space. That's what they were doing at Croydon. And that's the way in which they presented their case when we looked at both the nature of the pleadings and the nature of the evidence which they led. They then characterise a different level of business, meaning brokerage of serviced offices. Now we're going to come on and see actually how that, what the evidence shows as to how that was provided. And again, as a flag to where we're going, I want to be very careful about what actually the evidence established as opposed to what they asserted. The evidence established was that there was an easyoffice.co.uk website. That undoubtedly and ambiguously was advertising Croydon physical premises use. It also, this is where I'm going with this and where the evidence seemed to show, it also provided a referral portal itself to something which was then operated by Instant Offices as a different subdomain, as a different subpart of the website, in respect to which the court had no full evidence of actually what was going on and no transactional activity in relation to that. So my learned friend was a little bit generalist when you start saying it's all on the EasyOffice website. It's not. We fully accept the easyoffice.co.uk website was positively advertising offices to rent being their EasyGroup's own offices. That continued until they stopped using their own rental offices. But what it had also on that website was itself a portal or referral section, which then went down into a whole different mechanism, which on the evidence wasn't operated by EasyGroup at all, was operated by instant offices. And on the evidence, the best evidence we had was that instant offices, operated by instant offices. And on the evidence that we had, instant offices had been given some logos from EasyGroup in about 2007 to apply in relation to that. And that's as far as it went. So again, jumping ahead, what I'll be submitting when we get to the revocation part is that on the evidence that the judge had available, the EasyOffice.co.uk website, insofar as it was relating to use by instant offices, was itself merely a portal or referral to another referral agency, about which we do not know almost anything about the nature of the transaction that was being conducted through that portal agency, nor about the use of any relevant Easy Office marks in relation to that. That's jumping a long way ahead, but I hope it's quite a useful guidance of what I'm going to be saying, because that's what the judge was finding, and she made it quite clear, I think it's paragraphs 273, but I'll show you in a moment, of a judgment. But it is not the case that you simply have one website offering all services.
Sure. So, insofar as this is all going to non-use,
Yeah.
I understand the relevance of these submissions, but I thought you were addressing us on infringement.
I was.
And trying to make some argument to the effect that there's some kind of concession here.
I am addressing it on infringement. I did say that.
And at the moment, I'm really struggling to understand the relevance of this to infringement.
Let me try one more time. What I'm saying is it's not an admission, but it is consistent with EasyGroup themselves, considering that the services which are being provided, the business which is being transacted under the Easy Office mark, is being conducted in 3 different ways, 3 different services.
Undoubtedly 3 different ways, but on their case, 3 different ways of providing the same service.
Yes, and I'm saying, as a matter
So where does this get us?
It gets us this far. As a matter of commercial reality, you are considering the registrations from a practical, commercial, common sense way. One is rental of office space, another one is information and advisory, so forth. If the proprietor of the relevant mark in question says, one level of my business is operating serviced offices, another level of my business is providing brokerage, and another level of my business is providing offering franchisees, then in my submission, one starting point is to think, actually, even EasyGroup themselves consider that they are conducting 3 different types of business, i.e. providing 3 different types of services from a practical perspective under the relevant mark. I don't go any further than that.
Thank you. So where do we go next?
So, where we go next? Oh, yes, while we're still there, before I missed the point. Request 4, 5, and 6, just again flagging up so I have to come back here. So 4, please identify the precise legal entity which claims will say was the person engaging in the relevant act of use. Response, the claimant's case is that all the registered Easy Office marks have been carried out by or with the consent of the claimant. Further details 2 above. 5, if the claimant's case relates to an entity other than the proprietor of the mark, please explain the nature of the case on the authority of that third party to use the mark and provide copies of any agreements relied upon. This request is dealt with in 2 above. Beyond that information, this request amounts to an inappropriate request for advance disclosure and evidence to which defendants are not entitled at this time. So you can see where I'm going with that, my lord, or my lords. We flagged up right at the beginning, if there's something about the nature of the relationship with instant offices and the agreements that they're relying on, we expect to see it. We asked for it, they said they're going to address it in their evidence of disclosure. It didn't come as a surprise to them that when the evidence didn't address it and the disclosure didn't address it, that's a material fact the judge was perfectly entitled to take into account when she said they failed to give sufficiently cogent evidence of the nature of the relationship and the use of the market in respect to instant offices. So what we say as final solution in relation to the brokerage or serviced offices, we would say it's an absurd submission that to suggest that the brokerage or serviced offices of third parties' office space was considered to be the same service as providing rental of offices themselves. And the judge did not err in her assessment of the evidence, nor in her interpretation of the nature of the services when she came to consider that in relation to those specifications, it wasn't the same service, nor was it an ancillary service, but a different, albeit related one. Now, having jumped ahead, I probably ought to just address then what we say in relation to instant offices. The instant...
Well, sorry. Can we finish off infringement before we get into revocation?
Yeah.
And I appreciate there's a commonality of issue in terms of construction of services.
Yes.
But nevertheless, they are distinct issues.
Surely.
And I think we would find it helpful for you to conclude your submissions on infringement before we go any further into non-use.
Of course, my lord. When you've got already my overarching position as to where we're going with instant offices. Yes. So what the judge did find, and we say rightly so, is that there was identicality of use in relation to the advertising service, information services within EU TN 376. And that's consistent with our pleaded case, and it's not the case that we admitted advertising use in relation to 509 or 528 marks. And I need to show you the entirety of the pleading that my learned friend showed you a little passage on yesterday. So that's in the core bundle again at tab 30. And this is the amended defence and counterclaim starting at page 314. My learned friend relied on paragraphs 8 as being some admissions that we had advertised. Reading the pleading properly, you could go then please to paragraph 19 of the defence, which is page 320. 19A is the denial of identicality in relation to the mark and the sign, and pointing out the S at the end, absent words, difference would not be unnoticed by the average consumer. And 19B, save for advisory, consultancy and information services related to estate affairs and information advisory service specification, it's denied that the first defendant's services are identical to any services specification. So that was the position in the pleadings.
Well, fine. So you denied identicality of services, understood. But nevertheless, do you dispute that paragraph 8 is an admission of advertising the rental of serviced office space?
It's advertising rental of serviced office space provided by third parties. That's the admission that was being made insofar as there's any omission. And it's the same point that we're making all the time, that the directory provides an advertising service which allows third parties who have office space to rent to advertise through that portal. So it is an advertising service, it is not an admission that it is an act of advertising in relation to the provision of rental offices.
The judge found, didn't she, at two places in the judgment which you showed us yesterday, 190 and 301, that your website advertised offices to rent.
Yes.
Is she right about that?
As I showed you all the way through the entirety of her judgment, insofar as it's advertising in the same way I've just described to my Lord Justice Arnold, and it's got to be read in the context of where she finds actually what are the actual acts that have been provided by Nuclei, where she holds it's a portal service or directory service, which allows, as part of that, third-party service office providers to advertise through that portal.
But I've got difficulty with the proposition that you don't infringe a trademark merely because you advertise in relation to somebody else's services. I mean, you don't infringe if you advertise the proprietor's services. But if you advertise your own or somebody else's services, which fall within the specification of the mark, then you ought to be caught by the specification.
If what you're doing in relation to the mark is use in relation to the services for which it's registered. Yeah. So we do maintain what she meant, and why, when she explained fully about portal, is that the use of the mark EasyOffices would have been understood by the average consumer at all times as being the sort of global banner, just as Yellow Pages, just as Google would be, in terms of that's what that has been provided. It's the basis by which third parties can view advertisements placed by third parties who have office space to rent. So the use of the EasyOffices itself was not being used in relation to the service of providing offices. It was service of as a directory, or service as a portal, which allowed others to advertise. There was no in a sort of Celine sense, the average consumer would not consider the EasyOffices mark was being used as any sort of badge of origin or badge of identity or badge of support in terms of warranting the merits of the underlying serviced office which was being rented. What the badge was doing.
So if I rent an office through the EasyOffices portal, and it turns out to be a hole in the roof and infested with vermin, I don't hold EasyOffices responsible in any way.
Not for the rental of the office. It may be for the advice they were giving in relation to it, but not for the rental of the office itself. And so it is the advice or information service which they were using it for. They may be negligent in terms of the advice they were giving or the information they were giving on that website, but they were not liable for what actually the office.
So they'd have no hesitation in recommending EasyOffices to their business colleagues and partners as a result of that experience.
But it is important, my lord, to bear in mind what, especially with these service marks and being used on the internet, what is the mark being used in relation to? You've got my submission, but it's very much, I think, a more mechanical one. Sunday Times magazine has a section about office rentals, and there's a whole load of pages in a whole section on office rentals. The Sunday Times magazine masthead, or whatever, isn't being used in relation to provision of office rentals. It's been used as a magazine service, and as a matter of fact, is then a question, matter of fact, is that masthead being used in relation to service offices, or is it being used as a magazine service, or as a directory service? And
analogies aren't always.
They aren't always perfect, and I'm trying to give my lords something a little bit more historic in terms of use, especially when you've got internet services, when you've got portals going through portals going through portals. It is important to bear in mind what the average consumer understands by that portal, because otherwise it means Google's advertising everything under the sun.
All right, thank you.
Those are my submissions. I hope they are of assistance. That, I think, probably concludes infringement. What I will do is now go to, oh no, not infringement, sorry. That concludes the services construction point. I now need to do likelihood of confusion in relation to infringement, if I may. And we address this in our written submissions as second set of submissions between 39 and 53. And may I ask you to go back to the judgment at judgment 306. And what we say here is the judge set out the correct test, which needed to be applied when considering likelihood of confusion.
Yes, she even got the right form of the standard summary.
Absolutely. Hey, that's no good on that, which is the normal one in here, up here. But secondly, she also got the context right, which she then deals with in 307 as well. So she's addressed everything in terms of the correct law. She then goes on between 307 and 315 to deal with the difference between the infringement test and the invalidity test, 307, 308. The extent of evidence of actual confusion, 309 to 310, and the role of honest concurrent use, 311 to 315, even without having had the benefit of this court's later judgment in Musmatch. And my learned friends accept that, albeit brief, she was correct in what she set out in relation to honest concurrent use. What she then does, between 316 to 330, is to apply that to the material facts, and then come to a conclusion at 331 to 332. We say by doing that, she's applied the correct law, she's applied it to the material facts which she was entitled to find. There's no error principle there, either as law or factual assessment. She's not failed to take anything into account, and nor she's taken matter into account which she should not have done. The weight to be given to each of those factors was a matter for the trial judge, who had seen the whole ocean of the evidence rather than a few islands, which had been hopped on by my learned friend yesterday, and she was not clearly wrong. Therefore, it's not appropriate for this court to substitute a different opinion, even if it had it, in those circumstances. All the question of assessment of the evidence falling squarely within the remit of the judge. Now, at last count, I think my learned friend made 4 substantive criticisms in relation to this. They are apparently an alleged inconsistency with her findings on invalidity. Secondly, that the judge should have found confusion inevitable. Thirdly, that the judge placed incorrect weight on the absence of evidence of actual confusion, and asserts there was evidence of actual confusion she should have found. And fourthly, assessed honest concurrent use contingently, not as part of the overall assessment, and or applied the wrong test, and or it should not be applied in borderline cases, and or failed to make the relevant findings of fact to be able to conclude honest concurrent use applied. Now, I was going to deal with those briefly because, well, I'll deal with those substantively, but the first one, alleged inconsistency, my learned friend didn't rely on orally, but it's in his written submissions. I will deal with this one, therefore, relatively briefly, but we say it is wrong. Firstly, on any view, it doesn't apply to any of the device marks, because there is no inconsistency with the judge's finding of no infringement in relation to all the device marks with the invalidity case. Secondly, the judge addressed the different tests between invalidity and infringement, as I've shown you at 307 and 308. And it was common ground between the parties that the tests were different at trial. It's common ground, therefore, as a consequence, that the date of assessment is different, 2002 for the passing off case, and 2013 for the infringement case, and then the context is different. You have to consider actual use compared with notional use. The time difference is very important because what we're looking at now is an 11 years difference of period, which is consistent with honest concurrent use having been established, market being educated, and therefore less likelihood in 2013 as well as 2002. There's a different objective comparison. For passing off, you must consider the notional use of EasyGroup's word marks in 2002, so that their use could include use of the word marks in the same form as Nuclei's logo and for domain names on websites, which is more likely to give rise to the risk of deception, as opposed to considering the actual use of the EasyOffice's signs in 2013. Thirdly, as of 18th of October 2002, the only party trading under EasyOffice's sign in the provision of office brokerage services with Nuclei, no other entity was working in the field at all using an Easy Plus sign, and that's likely to give rise to a greater risk of deception in 2002 than would have been in 2013. Fourthly, the market and scale have grown significantly in those 11 years, and had any confusion been likely, it can be expected to have come to light by then. And while a likelihood of deception may well have been appreciated in 2002, by 2013 it had not transpired. My learned friend's second point, confusion is inevitable, is bad in law and principle. My lords are fully aware that what the court has to do under this analysis is to conduct a multifactorial assessment as set out in the test which the judge rightly set out at 306. It's totally wrong to presume that there will be inevitable confusion. Thirdly, my learned friend's accusation that the judge placed incorrect weight on the absence of evidence of actual confusion and asserted there was evidence of actual confusion. We only have 7 points to say why that's wrong. The first is that the authorities make crystal clear that it's a matter for the judge what weight should be given to the presence or absence of evidence of actual confusion. That is Lord Justice Minnitt's citation which in Harrods, which my learned friends actually rely on in their opening submissions at paragraph 30. My lords, in this court, in Match Group, made exactly the same point rightly at paragraphs 39 and 53 of the Match Group. And for my lords, note that's in the Authority Bundle 5, tab 55, page 516. Secondly, merely arguing that the judge should have put a different weight on one factor is not an error of principle. Thirdly, in any event, when making this assessment, the judge took into account 4 important considerations. Firstly, the time period of or duration of side-by-side trading. That's in the judgment at 320, 2007 to 2012. Secondly, the size of the respective businesses. That's the judgment at 325. Thirdly, the continuous nature of the use, judgment at 326. And fourthly, the opportunity for evidence to emerge. The judge did so at C judgment 326, some ways in which should have taken into account at 323 to 325. Having done so, we say the weight to be placed on the absence of evidence of confusion was a matter properly for the trial judge to do. Fourthly, all the points that my learned friend now seeks to rely on as good reasons as to why there was no evidence of actual confusion were considered by the judge. Nuclei's records were only to 2013. The judge considered. Yes, quite my learned friend's quite. Nuclei's email records were only available from 2013. That's a judgment 322. But there were countervailing points. Firstly, that EasyGroup's own records went back to 2003. That's a judgment 322. EasyGroup's disclosure review document said they had 17 million emails to review and over 2 terabytes of data. Secondly, in relation to this, EasyGroup positively sought evidence of confusion throughout this time, including by actively soliciting reports from members of the public on its website over a nearly 2-decade period. And if it had received any such reports, you can be sure they would have been documented and disclosed. That's the judgment of 323, 324. Thirdly, Nuclei's disclosure in fact included hard copy documents going back prior to 2013. And therefore, the suggestion that Nuclei failed to disclose any documents before 2013 was incorrect. Nuclei did disclose documents prior to 13, including printed correspondence going back to the earlier days of nuclear business in 1999 and 2000. But they didn't have electronic copies of email prior to December 2013 because they'd moved to a new email system, which was set out in the disclosure statement and which was before the court. No criticism was made of that by my learned friend at trial, and he's now again accepting no criticism should be made of that. But more importantly, Nuclei did have an archive of older hard copy documents, and EasyGroup themselves had a complete email repository. Fourthly, Nuclei led evidence by Mr. Abrahams that in his 20 years tenure at EasyOffice as the Chief Executive Officer of EasyOffices, he did not record any instances of confusion. That's Mr. Abrahams' second witness statement, paragraph 76 and 77. And this is despite having being the one answering the phone in the early years and working with a close-knit team who would have reported confusion to him had it occurred. That live evidence was given weight by the judge. She found him to be a genuinely reliable witness, judgment of 18. She was quite clearly entitled to do so. And fifthly, in relation to this, EasyGroup are saying in their first set of submissions of paragraph 45 that by the time of disclosure, i.e. 2020, the EasyOffice business was no longer operating physical offices. That's correct. Also correct that they were no longer operating any EasyOffice business at all by that time. EasyGroup has pulled out of this market under that name by that time. But what EasyGroup did give was disclosure of documents which were created during the time when EasyGroup was claiming to be operating both a physical premises business and a white label business. And that was the prime way that one would expect evidence of confusion of an internet business to come to light, and would be from emails from third parties. And there were none at the time. And that was addressed by the judgment at 322, 324, and 326.
Would
Now,
you expect people who were confused to write to your clients or to claimants?
both.
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 Why?
And in fact, that was Stelios' evidence in the W3 case. They had at least 12 examples of emails which had been written to them, especially when they actually had a positive site, a website passage on their website saying, van fees, anyone else using Easy is not allowed to do so, contact us in this section. And they regularly bring along and they plead in the numerous cases they come before this court, all those responses that they get. They had none in relation to this. Now, as to the alleged evidence of actual confusion, this was positively considered by the judge and positively and rightly rejected. The first one and the only one my learned friend relied on orally, is the September 2015 email, and that was considered and addressed by the judge at judgment 321 and rightly dismissed as speculation. It is correct, as my learned friend observes, that the defendants did not call Mr. Steyn. The matter in relation to this email wasn't raised prior to the cross-examination of Mr. Abrahams. It hadn't been pleaded, hadn't been referred to in any pleadings whatsoever, hadn't been raised in any opening submissions, hadn't been identified in any CA notice. It was just one of 7,500 documents buried in the disclosure, which was brought out during the cross-examination of Mr. Abrahams, who was giving evidence in the afternoon of the last day of oral evidence at this trial. And his answer in relation to this was, I've never heard in my 22 years anything like this ever being mentioned, and I've never had anyone being confused that we are anything to do with Stelios' companies. The references for that are SB1, tab 37, page 309 and page 314. But also, it's actually material to note what has been commented on in the Steyn email, and what it's certainly not anything to do with is the EasyOffice's logo or EasyOffice's name. To make that good, could I ask you, my lords, to take SB1 turn behind tab 26, where you'll see the email in question, and you'll see this is page 265. This is dated the 30th of September 2015, and what it says is the new homepage is not converting as well as the old one. As mentioned, I think it's more to do with people thinking the old website was Stelios more than this website is. And then conversion, let's get the homepage ranked better. As a whole, the PPC campaigns are converting better on the new website over the old. By the way, here are some examples of pages where just the pictures changed from the woman with the phone to the one related to the area, i.e. the new one. Now, those changes you can see in the same bundle at tab 25. Sorry, wrong reference, sorry. Tab 23. I do apologise. Tab 23. Page 234. It's the lady with the phone, and as my lords asked yesterday, is this the front of the page? And again, it's the difficulty of having lots of images without seeing the actual website itself. Without giving evidence, it appears the web page starts at 232, where you can see this being a removal, an extract from the front of the web page as at March 25, 2015. And you will see that that contains that image, 234. And you'll see the logo that's been used in relation to this is the EasyOffices in the square box logo. Top left-hand corner, which these pages. And just to make good in terms of the copyright notice, if you go to page 236, you'll see that the copyright notice in relation to this is EasyOffices UK 2000 to 2015. Now that's to be compared with the refresh page, which starts at 237, next page, and you'll see this is an image taken from Wayback Machine as a result of 20th August 2016, but as I'll show you, it was created in 2015. You'll see the logo is the same box logo, and if you go through the pages of this one, you'll see this now shows a picture of the office rather than a picture of the lady on the telephone. And if you get to page 244, you'll see the copyright notice, albeit slightly oblique, is 2015, even though this website capture is from 2016. So what Mr. Stain was commenting on was the difference between these two different web pages. If there's evidence of confusion, it's nothing to do with the logo, because the logos are materially the identically same form. EasyGroup have never sought to suggest that there is any material difference between these two types of logo. On the contrary, their pleaded cases, these two types of logo are to be treated as said. And that's the way they characterize it in their pleading. You'll see that in core bundle, tab 29. Paragraphs 19 and 20.
Sorry, just before you go there, I apologise if I'm setting a hair running here, but is there a misprint or some artefact of printing of the page page 240.
240.
Because I understand the point you were making earlier that printing out web pages is never very easy. And it seems to say big brands choose easy. Is the word easy office? Is the word office?
No, that was part of the branding of EasyOffices at that time. They also used fast, free, and easy. You'll see that on page 232.
Right. Okay.
And no
So it's
no
it's not an artifact.
No, it's not an artifact, and no allegations ever made that was an infringing use.
Okay, that's fine. Thank you.
So, what I was going to show you, I'm not sure I need to go there again, but I'll show you if you need to. What I was going to show you in the pleading at paragraphs 19 and 20, they say there are material changes in the use of figurative logos at the following dates: 5th January 2005.
Sorry, can you give me the page again?
Yes, of course. It's the Core Bundle tab 29, and it's paragraphs 19 and 20, page 309 of the Core Bundle. And you'll see in paragraphs 19.1 through to 19.4, where they say there are material changes in the figurative logos. And what we've been looking at are the 19.3 logos at all times. And I'll show you that most easily by reference to the judgment, where the judgment properly sets out a table which was culled from my learned friend's opening submissions at paragraph 28. Paragraph 28, the judgment, she sets out the nuclei logos and the periods in which they're used, and you'll see in relation to the third one that the EasyGroup's position was that each of those box logos was materially identical. It didn't draw a distinction between them. And therefore my submission is that whatever was being speculated about in relation to this email had nothing to do with the EasyOffice's name or logo get-up, but was actually, as the DeWitt email refers to, it's a sort of get-up of the homepage itself. But in any event, the judge obviously had Mr. Appellant's evidence in relation to that. He was a generally reliable witness. That's paragraph 18, and there's no challenge to the judge's finding in relation to EasyGroup in relation to that on this appeal. In their written submissions, they also suggest that the judge should have taken into account September, November 2003 emails. It wasn't relied on by my friend orally. The judge addressed those emails in any event at the judgment of 320, as also you can see from recognising 320, 324. And again, that could not be evidence of confusion with EasyOffice, as EasyGroup had not even traded as EasyOffice by that stage. And just for your notes, in relation to those emails, they weren't referred to in any evidence. They were mentioned for the first time in closing. The names on the emails were redacted, so no investigation could be determined as to whether or not they were genuine. And none of them were evidence of actual confusion for the reason I've just given. Rather, the fact that they've been disclosed in 2003 actually shows that EasyGroup had a sophisticated document, resource and archive system that if there was any material confusion of this kind, it would have been disclosed, and you can be sure it would have been relied on by EasyGroup in this case. And the judge, therefore, was right in her judgment at 323 and 324 to contrast the position with W3, where There were specific emails relied on in the evidence. They were investigated. And here we had no emails to Vanti's page relied on by Stelios and his witness named evidence at all. The sixth point in relation to confusion is that my learned friend asserts boldly at 22b of his third submissions that the onus of proof shifts to the defendant when considering likelihood of confusion. We say that's wrong. Maybe there's nuance about whether it shifts when you're considering honest concurrent use, but when you look at likelihood of confusion, there's no authority to suggest that the onus of proof shifts to the defendant. On the contrary, it's an infringement case for the claimant to prove their case. So we say that's bad in law. And seventhly, my learned friends.
But what about in relation to honest concurrent use? I understand your submission is that it doesn't apply to the cases where the judge found there was no likelihood of confusion, but this court has held that when it comes to honest concurrent use, then the onus is on the defendant.
Yes, and at the moment this court's held, I can't say at this stage that's wrong. That's your decision in match group. But I am going to suggest that is immaterial for this case. And one also has to consider what that actually means in honest concurrent use, where this court in match group recognised, for example, that in IPC and Advisor there was no evidence of education of the market at all. It was a judicial inference which you can draw from the facts as to there being side-by-side trading, even in circumstances where there are instances of actual confusion. So it does slightly beg the question what that onus actually goes to in relation to honest concurrent use. At a further place, I might be submitting that actually, given this court or the match group said that quite rightly honest concurrent use is just a factor in likelihood of confusion, then there shouldn't be any shifting of onus. It's entirely one of the matters which the court has to take into account as likelihood of confusion.
But how would that work in a double identity case?
Well, that's not a likelihood of confusion case. That's a double identity case where then there would be a burden.
So are you suggesting that honest concurrent use operates differently in the two contexts?
No, I'm not saying it operates differently, but what actually, there are a number of theories in which you can put honest concurrent use into the pot.
Well, one possibility is you shouldn't have regard to it at all.
One possibility might
it's not in the legislation.
What might simply be actually what that label actually is an indication of is this type of use, rather like descriptive use, isn't affecting the badge origin effect of the trademark in question. Because what it's recognising is the registered trademark in question at the beginning never had a true exclusivity, or at time infringement never had a true exclusivity into the use of that sign in the marketplace. And therefore it's one of those factors which you need to consider when you consider is this actually something which offends against this trademark, this registered trademark. Now, the reason I'm sort of speculating some of these points is that honest concurrent use usually comes in the circumstance where someone starts after the registered trademark has either been filed or died, and there's been a long period of co-use. We're a million miles away from that. We started before they even filed their mark, or even traded in relation to it. So this would be a case where you don't, in my submission, you wouldn't need, if like, honest concurrent use, because what you actually have is by the time the trademark has been filed, you have a pre-existing goodwill in the marketplace, which is distinctive of another party using a mark which is either, in the 10.1 circumstances, identical, or 10.2 circumstances, similar, such that the market has already been educated that whatever the registered mark, it cannot have covered exclusivity in relation to the use of the goodwill by the pre-existing user. And therefore, whatever the pre-existing user does in terms of continuing without making a material change in relation to that mark and that business and that use, that cannot inherently damage the trademark function of the registered trademark because it never had that full exclusivity at any stage. So these are all labels for actually asking yourself, actually, is this a material damage to the registered trademark? Now, and the seventh point, as I understand my learned friend, submissions, both orally and in writing, particularly in his third group of submissions of paragraph 22A, is that no weight should be given to the lack of actual confusion because, as I understand the submission, it's unsupported by evidence that consumers would not have seen the marks as registered. In other words, their main plank is that their own consumers, the EasyGroup's own consumers, wouldn't have seen the marks as registered, the Easy office mark in word form, but have only seen it in a logo form, and therefore unlikely ever to think there's any likelihood of confusion. That's just a bad point on the facts. Consumers would and did see EasyGroup's Easy office mark used in plain letter form. And you can see that from their own website as at 2007. I'd ask you to look at SB2, tab 3. And page 26, if you'll be so kind.
I think I'm in the wrong bundle.
Sorry, it's SB2. Sorry, it's the second supplemental bundle.
Yeah.
It's page. This example is page 26. This is an example from 2013. But they've been using this in this form, they say, since 2007. And you will see, just by way of example, if you've got this in landscape form, at the top left, obviously, you've got the EasyOffice.co.uk web address, and then office space to rent. Get your business off to the latest possible start with affordable office space from the Easy Office. And then the next paragraph, office rentals through Easy Office are available immediately from as little as 2 weeks and so forth. So they used Easy Office as in a plain letter form. And you go back to tab 2, page 25. No point doing that. Sorry, I apologise for bad reference. That just shows it comes from the EasyGroup.co.uk website. That doesn't help. It doesn't take us any further forward. But they're using Easy Office in plain form. And the evidence of Mr. Smith, which was given in hearsay, and that's back in SB1, I need to show you this one, is that these websites were getting, in between the period of 2006 and 2000, and that's like SB1, tab 15, starting at page 136, this is the witness statement of Mark Smith of 22nd of December 2019, 22nd of December 2009. We'll see that at page 144. And at page 144, he gives the website visits and page views. And you'll see there that between 2000 and 5th of December 2006 and 1st of September 2009, you've got well over 1 million page views, and you've seen the number of visits and so forth. And while you're there, I apologise for jumping ahead, but it is relevant for non-use. This is the evidence that they put in relation to a non-use attack in 2009, 2010. And the judge was right to contrast the nature of this sort of evidence with the evidence which she had before her. In other words, there's positive evidence here of the numbers of hits and views in relation to the EasyOffice.co.uk website at that period, and absolutely no evidence in the relevant period, 2014 to 2019. Also, while we're there, I'll just point out that this is given by, evidence was given by Mark Smith, who was the chief executive of EasyOffice, and he gave evidence by CEA notice in relation to these proceedings. And as the judge, I'm going to show you again, as the judge noted, that was unsatisfactory. Why was he not brought along to give any live evidence? We didn't even have a chance to address it.
Is there a misprint in these figures? Maybe it doesn't matter, but the first line seems to cover a 2.5 year period.
Yes. Let me have a look and say back, jumped ahead. 144.
Seems to sort of jump over the next line, which is January to December 2007, and the next lot of 2008, and the next lot of 2009. Is that corrected?
I can't assist on that.
Right.
He didn't come along, and
Anyway,
I wasn't interested in the
so it was
maybe different parts of the site. Who knows? Certainly, the impression this seems to give is that there were a very large, i.e., well in excess of 1 million page views. As the purpose of my submission here, it destroys my learned friend's submission that the likelihood of confusion would not have, in practice, well, the actuality of confusion would not have been likely to arise because they were not using EasyOffice in a simple form, but only a special getter. It is a bad point.
I think Mr. Malinich's point might have been that there's nothing in the judgment which makes it clear that the judge went through this exercise and realised that there were these different comparisons which ought to be made.
Well, she does make a comparison between the signs, the logo signs on the one hand and the word signs on the other. Right. And what I'm saying is implicit in that when she is entitled, as she did, to find that there was no likelihood of that the absence of evidence was a legitimate basis from which to infer there was no likelihood of confusion, was not rebutted by an assertion that in fact EasyGroup were not using the relevant mark or relevant sign at the time. Now, I may be wrong, I'll be corrected for that, but as I stand here, I don't remember this point actually being made before the judge below, but I will check to see whether that's the case. So there is an element of the judgment being brief, but not wrong, because not all the points were A, expressly and fleshed out and canvassed, B, even if they were, the judgment doesn't fall into error, because not every single point is expressed in minute detail. Now, again, just in terms of therefore where that leaves us, as I understand my learned friend's written submissions, and even his oral submissions, they still are not seeking to assert that the lack of evidence of actual confusion should be disregarded at all. They are just saying it's a question of weight. And once it becomes a question of weight, that was a matter that was probably for the trial judge. And we say she explicitly had this in mind, specifically in Judgment 310, the last sentence, when she was conducting the assessment. So we say, in terms of the likelihood of confusion analysis, none of the criticisms which my learned friends have actually raised amount to a challenge of principle. Rather, they are attempts to challenge primary facts and or the weight which should be given to some of those primary facts, which are matters which are entirely for the first instance judge and not for this court to intervene. There's now a further criticism, as I understand it, in his third written submission, 31B, that the judge should have considered a new assessment of the likelihood of confusion at each major refresh. The judge was fully aware of all the logos used by Nuclei. She set them out in the judgment 25 to 28, which I've shown you. And she considered them expressly at judgment 316. There was no evidence that any of the forms of logos or the plain letter forms gave rise to confusion. So we saw on the facts there's no evidence of that exacerbation. And there was no suggestion that the later two refreshes are likely to be more confusing than the one as at 2013. On the contrary, if you look at the logos, if anything, they're going further and further away from what could be possibly said to be similar to the EasyGroup registrations. So, therefore, it's an entirely theoretical point. Again, one wasn't in fact pressed before this judge to say there's a particular date you've got to reconsider because the case is no much better when you consider this logo as opposed to that logo. That was never put. There was a statement in their written submission saying you've got to assess each material change, but there's no submission as to why it's different in any relation to any of these logos. So it's had no materiality in this claim or in these proceedings, and therefore, while it's correct, there's no theoretical jumping by the judge through each of these, it wouldn't have made a difference. And she was right not to consider it. What? Yeah. And as my junior qualifies at 316, does actually refer to the difference and to go with. Now, that takes me on to honest concurrent use. Again, we've addressed this in our second set of submissions at 46 to 53. And at my last count of my learned friend's position, he says the judge got this wrong in 6 different ways. The first is by addressing it contingently. The second is that it should be excluded from borderline cases. Third is that she failed to state in terms that the EasyOffice, as opposed to EasyOffice's marks, act to denote different businesses. Fourthly, they contend that use has not been sufficiently substantial for honest concurrent use to be engaged. Fifthly, they contend that the defendants have exacerbated confusion. And sixthly, they say that Nuclei's use was not honest. Let me deal with them in turn, if I may. The allegation that the judge assessed honest concurrent use contingently. Common ground in light of Match Group that honest concurrent use was a factor to be taken into account as part of the overall assessment. And that is precisely what the judge said she was doing. So the last sentence of judgment 315. One of the factors you can take into account. The exercise which you then performed between paragraphs 316 and 330 and at 331 and 332 is doing that overall assessment, taking the factors sequentially as she goes through the process. It's not an error of principle. She wasn't conducting contingently. The fact she addressed them sequentially is not saying that she was applying contingently. In any event, even if she did apply it contingently, even if she didn't, it would only ever be a point in favour of my learned friend's clients. Honest concurrent use could only ever point away from a likelihood of confusion. It could never add to a likelihood of confusion. And that's what a judge effectively recognised at 331 of her judgment, because what she does there is apply all the relevant factors and saying, even without taking honest concurrent use into account, I find in relation to figurative marks, there's no likelihood of confusion. She doesn't need to ask about putting the HCU, or honest concurrent use factor, into the pot. And that's quite right. Secondly, they contend that honest concurrent use as a matter of principle should be excluded from borderline cases. We don't understand where they get that extraordinary submission from. There's no authority for it. If this issue is raised, it's a matter which needs to be taken into account by the judge and given such weight as the trial judge considers appropriate. And in any case, in this case, this wasn't a borderline case. The facts of this case are such that the judge held that it gave rise to a strong case of honest concurrent use, And you can see that in the judgment at page 330. Sorry, paragraph 330. Third point, the suggestion that the judge failed to say in terms that EasyOffice and EasyOffice's Mark Act denote different businesses. Again, we say that's a wrong and illegitimate reading of the judgment. It's the logical consequence of this judge's finding and the entire rationale of honest concurrent use. EasyGroup accepts the judge correctly, if not comprehensively, addressed the principles of honest concurrent use in her judgment at 311 to 314. That's in their EasyGroup's first set of submissions, paragraph 54. At 311.2 of the judgment, the learned judge quotes from the late Mr. Justice Henry Carr in IPC and actually in Victoria Club. And in relation to 311.2, Mr. Justice Henry Carr said this will be the case where the trademark serves to indicate the goods or services of either of those entities as opposed to one of them alone. In those circumstances, the guarantee of origin of the claimant's trademark is not impaired by the defendant's use because the trademark does not denote the claimant alone. Now, that's also the submission which I put in my Lord Justice Arnold when you're considering all of these cases, whether it's prior or afterwards. But that is clearly what honest and concurrent use means, i.e. it doesn't exclusively denote the claimant. And the judge clearly had that in mind. And as to the facts, the judge was entirely justified to come to that conclusion because Nuclei had begun trading in 2000 in the EasyOffice's sign prior to any use of EasyGroup of its EasyOffice marks or filing them. That's the judgment 330. EasyGroup knew since 2001 at the latest that Nuclei was using and was continuing to use EasyOffice's mark in relation to its business, and EasyGroup had accepted undertakings that Nuclei would not use orange and white as part of the get-up. That's a judgment 48 to 54. By the time of filing the EasyGroup's registered trademarks in 2002 and 2013, Nuclei had a pre-existing goodwill in its EasyOffice's sign, meaning that the EasyOffice's sign was distinctive to a relevant public, including Nuclei's customers and potential customers. That's the judgment at 190 to 191. If EasyGroup's registered trademarks are valid, it's to be presumed those marks are distinctive to a relevant part of the UK public. EasyGroup, having taken no steps to restrain EasyOffice's use since 2002 of the EasyOffice's mark, means the relevant public has been educated that the two marks each designate different legal entities by at least 2013. That is the inevitable judicial inference which you draw from those primary findings of fact. The more so in evidence of actual confusion, which is corroborative that in practice the signs are perceived as being sufficiently different and was designating different entities. Yeah, did I say in the absence? I hopefully said in the absence of evidence of confusion. And as this court noted in Match Group, that is a legitimate judicial inference that can be drawn, namely that the relevant class of consumers have been educated to understand that EasyOffices was unrelated to EasyOffice without need of any direct evidence to that effect. I ought to show the court that it's in the authorities bundle at authorities bundle 5, tab 55. And if I can ask my lords to turn to page 1540 of the electronic bundle, paragraph 120 and 121 of the judgment of Lord Justice Arnold in Match Group. 120, counsel for the claimant submitted that even if the defendant's concurrent use of the signs complained of had been honest, there was no evidence that most of the relevant class of consumers had been educated to understand that Musmatch was unrelated to match. It's fair to say, however, that there does not appear to have been any positive evidence of such consumer education in either Budweiser or in IPC and media. Rather, the conclusion that most consumers had learnt that Budweiser denoted two different beers and that the Ideal Home denoted two different businesses was a matter of judicial inference from many years' parallel trade on a substantial scale. Although the judge did not in terms ask himself whether most of the relevant class of consumers had been educated to understand that Musmatch was unrelated to match, I consider that is clear from his analysis of the likelihood of confusion. If he posed himself that question, his answer would have been negative. Rather, the essence of his analysis was it was likely that a substantial portion of the relevant class of consumers encountering Musmatch would assume that it was related to match in the manner he described. In this case, obviously, it goes on to find ones that currently still apply. And that, we say, is what this judge did by parallel reasoning in relation to the EasyOffice and EasyOffices signs. Fourth point, I think they say, is that, and this is in their third submissions, paragraph 30 to 31A, they say that the use has not been sufficiently substantial. We say that's not open to them as a matter of fact in this case, in the light of the judge's findings at judgment 325. And her findings of substantial side by side trading 326. And obviously, crucially for this type of use, her finding that EasyOffice's Nuclei already had a pre-existing goodwill as of 2002. That's a judgment finding at 190, 191. Fifthly, EasyGroup suggests that the defendants or Nuclei exacerbated confusion. That's their first submissions, paragraphs 61 and 62, during the limitation period by getting closer to EasyGroup's marks. That's not correct as a matter of fact. I have shown you the relevant logos which have changed through the period, and our submission in relation to that is, if anything, the logo was going away from whatever the claimants could legitimately claim to be their distinctive aspects of their device marks. And that obviously would lead to the same submission I was making before, that if there had been a separate assessment in relation to those different dates, say February 2015 or November 2019, there'd be an even less likelihood of confusion because the logos are even further away. And sixthly, the suggestion that the defendant's use or Nuclei's use was not honest, or somehow not in accordance with honest practices. The summary point in relation to this is this has to be a bad point because the judge had found that EasyGroup's use was predated by Nuclei. Nuclei had a pre-existing goodwill. At the time of 2002, when they had a pre-existing goodwill, there was no use by EasyGroup at all. There was no suggestion they had any rights at all. They didn't even file their registered trademarks until October 2002. And the judge is finding that there's been no exacerbation subsequently. At 330, nor was there any evidence before me suggesting that Nuclei's use of EasyOffice's signs has taken unfair advantage or has been detrimental to the character of reputation of marks. That's a simple answer. My Lord, if my Lord's interested in doing a slightly more detailed analysis in relation to good faith and honesty, I am aware that obviously in the Samuel Smith case, my Lord set out a number of factors, my Lord Justice Arnold set out a number of factors as to whether or not something would be considered to be in accordance with honest practices. We could go through each of those, but they all found in favour. Once you do those as a checklist, just ask yourself, is this case likely to find that what Nuclei were doing, were they acting in accordance with honest practices in the trade? The answer is yes. But they all come back to the same fundamental point. if you pre-use someone and have established a goodwill, it cannot be dishonest or not in accordance with other practices to carry on doing that business in materially the same way thereafter. No pre-knowledge of the registered rights. You haven't in any way encroached upon the registered rights because you already had them in the first place. The registered rights are applied for in circumstances where there is a pre-existing goodwill. And unless the registered right owner does something about that, which they didn't in this case, they stood by and let, rightly we say, us to continue to trade, then there will always be two communities, one of whom thinks of EasyOffice as being a badge of origin in relation to EasyGroup if they use it, and another which thinks of EasyOffices as being a badge of origin of us. And that cannot therefore mean that you're encroaching or ever encroached upon the trademark function of the second later mark. That, I think, now does deal with the infringement awards, and I was going to then go to non-use revocation. Yes, I'm reminded whether that's no comments for the transcript writers. I'm happy to continue, but...
Well, we didn't give them a break yesterday, and I appreciate the burden on transcribers, but it isn't the normal practice in this court to break, so I think we will adopt the same course as yesterday.
I'm conscious I'm garbling and tend to rush, but let's get on with revocation. What I want to show you are the key final bits of evidence relied on below in relation to this. Then we've looked at the case, and then I want to address each of the alleged errors of principle that my learned friend seeks to rely on. For your notes, we've dealt with the body of these complaints in our second set of submissions between paragraphs 6 and 21 and between paragraphs 54 and 71. As to primary evidence, my Lord, I've already shown you that this is an extraordinary case where EasyGroup had led no live witness evidence from any person who had direct knowledge of the alleged use of EasyOffice marks in the period after 2011, none in the relevant period whatsoever. I've also shown you, obviously, that wasn't what EasyGroup had intended to be the case when they started this trial. They put forward Stelios to give a portion of direct factual evidence both as to the coin use and the instant office brokerage use. That evidence has fallen apart. What there was also before the court, my lords, so you have a slightly bigger picture of the sea rather than just a few of the islands, but it's still island hopping, I apologise, but that's the only thing that I can do at the moment, is to show you three key disclosure documents about the Croydon use. And so could you take the supplemental bundle 2, please, and turn to tab 22 first. And my learned friend took you to this very briefly yesterday morning, pages 244 and 245, but it is important to have regard to the dates in relation to these images. These are the only images that were put forward as to the physical premises at Croydon, and they weren't put forward by the EasyGroup, they were put forward by my instructing solicitor who had done some research in relation to it. And what you can see is that as at September 2012, the building was still branded MetLife. By June 2014, it had no external branding at all. And by June 2015, it was holding itself out as easyhotel.com. And by October 2015, it was still easyhotel.com. This is meant to be the EasyOffice building at Croydon, or EasyOffice premises at Croydon. Secondly, if you turn back to tab 18, and pages please 231, 232, 233, 234 and 235. These are the only images in the entire disclosure given by EasyGroup of what the EasyOffice serviced office provision was at Croydon. Again, absolutely no branding or use of EasyOffice in relation to it whatsoever. And the third one, just to give a slightly fuller picture at tab 5 of the very many emails my learned friends put in this bundle. By way of example, if you turn to page 133, you have an email from Nick Robertson. He's of Croydon Council. This was sent, you'll see, to Old Street at easyoffice.co.uk and easyoffice.co.uk by 29th of May 2014, by which time Easy Offices at Old Street had long since closed, common ground. But the materiality is that what he's asking for is I'm currently working to update our service to office flexible office information that we're holding for advising businesses looking for flexible space. I was hoping you'd be able to provide me with some information on the maximum capacity of Easy Office Croydon, current availability and the type of clients you have currently. Not a single jot of evidence or materials or disclosure to suggest that was ever replied to.
Sorry, I apologise if I'm being dense, but what's the relevance of the fact that it was sent to Old Street at easyoffice.co.uk,
So
given that the inquiry is explicitly about Croydon?
Yes, because that's what you reply on when you go on the website. What that's further indication of is the website had not been updated because Old Street had been long closed by May 2014.
But it goes to two addresses. It also goes to at easyoffice.co.uk.
It does, but it's the subject line of what this is sent to Old Street. Do you see that? Easy Office.
No, the subject line is Easy Office, email us form submitted.
Yes.
And the office location is specified in, and these are the fields in the form.
Yes.
Office location is Croydon.
Yes.
And the inquiry is about Croydon.
Yes. And I'm relying.
So, and I take your point about absence of any evidence of a response, but you seem to be making some other point, and I'm struggling to understand what the other point is.
The other point is, my learned friend rightly accepted in closest wishes to the court that the website was not kept up to date. This is evidence of the website not being kept up to date. Because
But why? Because Mr. Robertson clearly understands that there is space available at Croydon.
Yeah. He understands that he's asking in relation to Croydon here. I'm relying on my primary submission, my Lord was God. I'm relying on this as being clear evidence of this. If this is real commercial use, you'd expect a query like that to be responded to and full details provided, and there's no evidence that ever happened. What I'm relying on as very much a secondary point is that it is surprising, we say, rhetorically, that if you've got an active business, that you still continue to have a Old Street address for your Easy Offices business, when that Old Street address had physically long closed and not been available. Now, it's not the biggest point in the world now, but it is consistent.
But the person using the form probably wouldn't have been aware of what the email address was, because it's just clicking on the website, you fill in the form, and you press submit.
That may well be right.
So one doesn't even know that the address would have been visible to the user.
That
I mean, if you've got evidence to the contrary, by all means show it.
No, I haven't. I haven't. As I said, it's a secondary point, but nonetheless, it is of a piece, I say. The primary point, as I've pointed out, is the lack of any response. Now, I've already shown you yesterday that Mr. Stelios serves a further witness statement in W3, showing that, stating purportedly that liquidator has been appointed to the EasyOffice company in 2012 and had not rented service offices subsequently, but had continued to operate a brokerage service via the online booking facility. The final little element I just want to make good is that my learned friend seeks to suggest there's evidence of prior use, and there's a lot of continuity which has been taken into account by the judge of use. There was no live evidence of earlier trading. The best that they had were the two CA notices given in relation to two witness statements of Mark Smith. And those relate to, amongst other things, instance offices up to March 2008 and up to September 2007 in his second witness statement. There was no evidence, even in those, of relevant period usage. They were given by a CA notice, and as the judge held at paragraph 17 of her judgment, in addition, EasyGroup sought to rely by way of CA notice on two witness statements made by Mark Smith, former CEO. They were made in revocation proceedings brought by Parker against 509 in 2009, in opposition brought by EasyGroup in 2008 in relation to trademark applications made by Nuclei. Those witness statements address circumstances when EasyGroup first started to consider the service office industry and so forth. Sole reason for not calling Mr. Smith as a witness was that he was no longer employed by EasyGroup. That is a rather unsatisfactory reason for his non-attendance as a witness, particularly given the other EasyGroup witnesses, Mr. Richardson and Mr. Jones, have likewise not been employed by the company or any related company for some years. In the event, however, background information provided in Mr. Smith's witness statements were not materially disputed. That's quite right. But what they had was apparently access to the Chief Executive Officer of EasyOffice and the person who was running the EasyOffice business, and they chose not to bring him along as a live witness. So,
did the evidence show when he ceased to be CEO? Because plainly he was CEO at the dates he made the two witness statements. I think the last of those was 2010.
It was. And the evidence didn't. We know the company went into liquidation, administration, I think, in
2012.
2012, yeah.
So he may have ceased to be CEO at that time.
But that may be right. But in terms of coming along to this court and saying there's a whole good batch of continuous use prior to that date, this court must be aware there wasn't any live evidence about earlier use. All we're left with is CA notice in relation to the use as up to 2007 and 2008 in the CA witness statements. So again, on this appeal, what EasyGroup is seeking to do is to construct a narrative from documents alone, but this time without having any relevant witness statement evidence at all, and with the additional burden of demonstrating a distinct and material error principle by the judge in her analysis and assessment of the material before. I've shown you the way the case was put in the pleadings. That's some further information. And now I'm going to attempt to address the various errors of principle, which I think I can probably group together in three groups, based on the way in which it's put in their grounds of appeal. Firstly, the construction of the services. I've already addressed that, obviously, when considering infringement award. We say the judge is right to hold that in relation to instant officers arrangement, this could only be relevant to the 376 mark, as instant officers was providing a brokerage in the same sense that Nuclei was being providing that service, and the evidence was that instant officers was directly competitive and thus was not itself hiring or renting of physical premises. And we do then say the judge is right to assess the use in relation to rental or hire of physical premises as relevant to deployment use, and then to assess the nature for the additional services in 376 in relation to the instant officer arrangement. That's because the nature of the services which were alleged to have been provided by EasyOffice at Croydon was the provision of hire or rental of physical premises, whereas the nature of the services which instant offices were providing were portal services in a manner which was similar and identical to and competitive to Nuclei. Even if we'd be wrong about that, and the judge should have combined both uses, that wouldn't have assisted EasyGroup, we say, because EasyGroup argument on construction was entirely academic when you consider, firstly, that the judge made findings of fact that EasyGroup's evidence was insufficient to make good a case of genuine use in relation to 376 in relation to the instant officer's use, which was held by the judge to be identical services. He made that finding as a result of a multifactorial assessment which he was entitled to make, judgment between 272 and 283, and which involved a close analysis of the evidence that was before her. Similarly, she made finding the fact that EasyGroup's evidence was insufficient to make good a case of genuine use in relation to any of the marks in relation to the Croydon use, which was common ground related to the use of identical services, namely hiring of temporary office space. Again, she made a multifactorial assessment in relation to those in a way she was entitled to, and that's in the judgment at 263 to 271. So, on one view, we say the better view, the construction issue is entirely academic, because by itself, in relation to revocation, because the judge has found 376 identical in scope, she's found, and she's found in relation to Croydon, all three marks would be identical in scope, but as a matter of fact, genuine use wasn't shown in relation to any of them. As to de minimis and that the judge applied the wrong test when considering genuine use, she applied a commercial threshold. Could I ask you to turn back to the judgment at 254, please, where, as I learned from rightly accepted, the judge correctly set out the principles of Mr. Just Arnold, who then was in London Taxi Corp and Fraser Nash. Although you were taken to that case, the only passage that my learned friend relied on were actually the very material passages which the judge has set out in her quotation at 254, the judgment. At 255 to 258, the judge then considered further authorities addressing a situation where there is commercial use and minimal use. 256, she expressly refers to Viva, which again this court was taken to, and as this court will have seen, will take into account all facts and matters.
Yes, well, in your submission, is what the judge says at 256, what subparagraph 1, a correct statement of what the Court of Justice held? Because what she says is the CJU upheld the conclusion of the Board of Appeal of OHIM that chocolate sales from a single shop in Bad Reichenhall, Germany, did not amount to genuine use of a trademark. Now, Mr. Maliner's submission was that that is an incorrect statement of what the Court of Justice held. All that the Court of Justice held was that the General Court, whose decision it was reviewing, had not fallen into any legal error.
That is strictly correct. But if the General Court had been wrong, it would have fallen into legal error, and the Court of Justice would have said so. Because the same principles of appeal as we have in this court. If there's an error...
No, I'm sorry, that's not right. On appeal from the General Court to the Court of Justice, the reviewed jurisdiction of the Court of Justice is more limited. It's limited to a pure error of law.
Lord, let me just...
The Court of Justice has stated time and again that it has no jurisdiction to review the facts on an appeal from the General Court.
What the Court of Justice says at 35 in REBA.
Remind me which tab?
Sorry, this is tab 61. So I should go to 1602 first. 33. What the Court of Justice is doing at the bottom of 33, according to case law, court examined the second step whether the Chamber of Appeal of Owen had considered all relevant facts in relation to each other. Thus, following their finding, these frameworks will always be extensive orders. Series examined type of goods and so forth, taking into account all the quantities and so forth, made a comprehensive assessment framework into it, established a certain interaction between the factors of genuine use. Therefore, the court therefore applied the term genuine use and did not commit any legal error in its examination. The appellant's submission is therefore unfounded. As far as the appellant's submission regarding the consideration of advertising for its trademark via the internet and the marketing concept is concerned, it must be noted the Court of Justice thereby asked to substitute its own assessment of facts and evidence with that court, first instance. Except in cases of distortion, which is not claimed here, such a submission is not a legal question and such must be reviewed by the court and therefore is inadmissible.
Exactly. So it has no jurisdiction to review the facts unless the facts have been positively distorted.
Yes.
And that wasn't suggested.
No, but that, with respect to the submission I'm making, if it was wrong, because so wrong that the earlier tribunal...
But distortion wasn't argued, Mr. Van Heegen.
I agree, and what I'm pointing out is that if there had been, my submission is, if on those facts were in any distorted, in other words, they were so that taking those facts along would have been so wrong that it could amount to genuine use, that would have amounted to a distortion, and so plainly wrong that the Court of Justice would have had jurisdiction to entertain it. And even if I'm wrong about that submission, even if strictly there's a more limited review in the Court of Justice, to say that there's no error of law, in substance, it was correct summary of the facts. The judge was, in summary, in her paragraph 256, in summary was making facts found by the Board of Appeal and that no error had been committed.
What do you say the judge is saying in the introduction to the case law that she cites?
Yes, I'm coming to that. What I am saying is exactly what I had put in my note before Lord Justice Nugee made the point to my learned friend yesterday, which is that what she is saying there is that she's just paraphrasing what Mr. Justice Arnold in London Taxi done at paragraph 8. And by not itself sufficient meant it's not always automatically the case, rather must consider the factual circumstances of each case. And my submission is, not only is that consistent with her then subsequent citation of the authorities, it's also consistent was what she then did in terms of analysing the facts thereafter. She did not, as a matter of fact, when you look through the remainder of the judgment, apply any threshold or minimum quantum test. On the contrary, she took the quantum of business into account. My submission will be she was entitled to do that. Moreover, she was told by counsel for EasyGroup to do that when making this assessment. And we do say, therefore, that if you look at those cases in 2562 and 3, there are also instances of where that factor has got to be taken into account, not saying minimal use can never be sufficient. And it is, as I said, consistent with the way in which my learned friend actually put the case to the judge in his closing. And I need to make that good. Could you take SB1, please? And turn to tab 37. Page 319 of the bundle. Page 685 of the manuscript, and I pick it up at line 5. I don't find exactly, you know what my answer is to those. First of all, you can say it's too trivial because triviality applies as kind of quantitative threshold we need to reach, which there is not. There's no de minimis test in say of law. So by the same token, that he cannot say to me, you cannot say that even one commercial use is sufficient, I can say that's right, but equally there's no de minimis test. For that reason, as I will show you, the test is basically multifactorial. The quantity of use is taken into account, the regularity, intensity, and so on. The only silver bullet is sham, and that's why I start with that. And he repeats the same submission again at page 323, at manuscript page 698, picking up at line 23. Be very wary about judging different cases by different facts. It depends. Everyone agrees that the quantity of use is relevant, and Reba is only authority for the proposition that it's a commercial use is not necessarily equated with genuine, a point I conceded earlier. So, referring to those cases, and in light of my learned friend's submissions, we are saying is not evidence of her applying a different test. She was being asked to take into account the quantity of use when assessing whether it's genuine. And then paragraphs 257 and 258, she expressly cites little when considering whether a given volume is sufficient. It's necessary to have regard to the characteristics of the products and services in the relevant market, as well as other relevant characteristics. The smaller the commercial volume, the more necessary it is to produce sufficient evidence. It's further evidence that she wasn't adopting a de minimis test, and I do need, given the way in which my learned friend developed his argument yesterday, I need to show you a little very briefly, if I may, please. That's in Authorities Bundle 6. Tab 66. And this is a judgment of the General Court. It's a revocation action. For this purpose, I think the facts matter, but you can see that what they are, paragraphs 1 through to 5, pH, plasticos, hydrosolubles, as a registration for green cycles. They're in various classes set out in paragraph 3. Little sought to revoke, there's in paragraph 5. Items of evidence were put in to establish genuine use. It was partially revoked. There was an appeal. Board of Appeal dismissed the appeal, and then it came up to the General Court. The actual facts don't matter. What's important for this point, if I may, though, is take you to the key paragraphs of level 24. Page 1648. When assessing whether use of trademark is genuine, regard must be had to all the facts and circumstances as well as to establishing whether the commercial exploitation of the market is real, particularly whether such use is viewed as warranted in the economic sector concerned to maintain or create share in the market for the goods or services protected by the mark, nature of the goods or services, the characteristics of the market, scale and frequency of use of the mark. 25. Moreover, genuine use of the trademark cannot be proved by means of probabilities or suppositions, but must be demonstrated by solid and objective evidence of effective and sufficient use of the trademark on the market concerned. It's necessary to carry out a global assessment which takes into account all the relevant factors of the particular case and entails a degree of interdependence between the factors taken into account. 31. Yeah, independence there you'll see in 25 just means the different factors against each other. Again, that includes scale and duration and so forth. 31, the next page, the turnover and volume of sales of goods under the contested trademark cannot be assessed in absolute terms, but must be looked at in relation to the other relevant factors. And then, such as the volume of business, production or marketing capacity, or the degree of diversification of the undertaking using the trademark and the characteristics of the goods or services of the relevant market. So specifically, the General Court is saying you must take into account, amongst other things, the marketing capacity of the undertaking. We're going to come to that, because Melenford makes a point in relation to that. Accordingly, use of mark need not always be quantitatively significant in order for it to be deemed genuine. Even minimal use can therefore be sufficient to be classified as genuine, provided that it is regarded as warranted in the relevant economic sector and as means of maintaining or creating a market shares for the goods or services protected by the mark. Therefore, it's not possible to determine a priori and in the abstract what quantitative threshold should be chosen to determine whether use is genuine, with the result that a de minimis rule which would not allow EUIPO or appeal the General Court to praise all the circumstances of the dispute before it cannot be laid down. And then 33, finally, the smaller the commercial volume of the exploitation of the mark, the more necessary it is for the mark to produce additional evidence to dispel any doubts as to the genuineness of the use. And that's fruit of the loom. Yes. Now, the judge, as I'm going to show you, expressly cites paragraphs 31 and 33, I believe, in her judgments at 257 and 258. So, in our respect for submission, she shouldn't be criticised for setting out the law. Similarly, paraphrasing in 256 is not to be criticised when having regard to the paragraphs of the judgment immediately preceding and the two paragraphs immediately following. There's there, we respectfully submit, of unreality by my learned friend in trying to find an error principle which is not there. Now, moreover, as I submitted to you, when applying the law to the facts, it's clear the judge is applying the correct law. She did not apply a threshold or de minimis minimum standard. And you can start seeing that from judgment 263, when she defines the facts. She took account of the fact that there was office space being available, even though the evidence was thin. 264, she took account of the scale and frequency and use of their mark, not finding that the level of use is per se insufficient on its own, just findings of what there was. At 265, she assessed the duration of use on the evidence before her, i.e. finished by September 2014 at the latest. Judgment 266, she makes findings that there were no further customers, which was open to her in light of the materials before her, i.e. taking into account scale and frequency of use. 267, she considers the marketing, finding a fact at the beginning of the paragraph that there's minimal marketing activity for the recording premises, and it contrasts what EasyOffices did in 2007. That's the judgment at 268, which we say she was entitled to do, draw that inference based on what Little is saying at paragraph 31. You've got to take into account the marketing capacity of the party or the party using the mark. She was told she must take that into account, and she did. She drew the comparisons what they did in 2007 as opposed to what they were doing with Croydon as at 2012. Now, pausing there, she expressly considered in 267 Google adverts, emails, and flyers. No suggestion that she missed any type of advertising. Insofar as there's any sort of suggestion that the judge did not consider easyoffice.co.uk website as advertising, that is wrong and misleading. The judgment starts in relation to all this starts at 263, where she says as regards the point premises, I've already noted the factual evidence regarding the precise location and so forth of the business. That's a cross-reference back to her judgment at starting at paragraph 40. Where 40 she talks by 2012, tide of turn, customer numbers were decreasing. In 1 week in August 12, there were just 25 transactions across all the EasyOffice branches. The occupancy rates around 30% per day. Declining customer interest led to closure of branches. And by February 2013, only Wimbledon and Old Street were listed on the website. And I've shown you 41. I've shown 42 is the purchase of the buildings. 43, not entirely clear from the evidence before me when EasyOffice in Croydon opened business, or even it was located in the same building. But Roman 1, in August 2013, the EasyOffice website announced the opening of new office space and solicited emails of interest. In October 13, EasyOffice emailed customers at Old Street location, advising the intent to move and so forth. So she had in mind the EasyOffice website being used as a way of advertising Croydon before she even got to 263 at the judgment. Going back then to the substantive consideration of the matters in the judgment itself, at 269, she considers the amount of spending amount spent on advertising against a backdrop which had previously been spent and against the sector in question, and the fact, importantly, the fact that it failed to result in any customers and no further attempt to be made to market business throughout the time open for bookings. And that's again consistent with saying, with the example which I've shown you of a failure to follow up inquiries from the Croydon Council or make any real effort to market the office location. At 270, you'll see our submission at trial was that on the basis of that material, this use was a sham. Because if EasyGroup really wanted customers, it would have marketed to try to get them. It had the capacity to do so. It could have branded the offices. It could have branded even the internal offices, but didn't do any of that at all. And especially when the first effort to market failed, it made no effort to remarket. Specifically when EasyGroup was a well-established and sophisticated business, it previously spent a lot more. However, the judge didn't accept that submission. It was a sham. She said, shouldn't you go that far? What she did properly is to go back to apply the legal test, namely asking herself whether there's a genuine use of the market to create or preserve a market share for the services when considered in the context of the characteristics of the sector and of the business in question. And we say there's no error of principle there. And she pulls that all together in 271. And this is not evidence, therefore, of a judge applying a de minimis threshold or a commercial success threshold. On the contrary, what she's doing is addressing the extent of use and all other relevant factors. One of the relevant factors, my lords, which you haven't been shown or told, is EasyGroup's own position in relation to the scale of use at Croydon. Could I ask you to take supplemental bundle 1, please, and turn again back to tab 37, please. Pick it up at page 320. And this is manuscript page 689, line 18, the judge, and we've established that Sestelios cannot give evidence as to the extent of use at Croydon. So you say, I have to take the documents essentially for what it's worth. The documents show that there are a few deaths booked by a couple of customers in Croydon in 2014, and the question was whether that is enough. Answer, no, it's not enough on its own. That's the very point. It's the same with all revocation cases. You have to mosaic the evidence and see what it shows. You have to stand back and get an impression of it. If you look at any of the particular piece of evidence, you could say on these invoices or booking references, there's not even the name EasyOffices on the website. It does not show that a single booking was received. No, but you have to read them together with a booking reference. They ought to be read together. There's a decided authority extent requirement, that's pretty clear. So what the judge had been told was in terms of actual scale of use at Croydon, that wasn't enough anyway. She needed to find more. And then what the poor judge then tries to do is for the next couple of pages, in fact, down to 699 manuscript line 4, she tries to find out, well, what are the other things that she's got to be taking into account? And in summary, all we get is the premises themselves, the promotional activity being the Google AdWords, the bookings, the flyer, and the website. And what is quite clear in these oral submissions is that whilst there's a link in the website to Instant Offices, there is no attempt by EasyGroup at this stage to suggest there should be any pulling up by bootstraps by taking into account Instant Offices anyway. So all the factors that she was asked to consider, she specifically considered when she gave her judgment. And at 271 of her judgment, I'm sorry, that one was finished the transcript. If we go back to judgment at 271, what the judge specifically considered, therefore, was both the extent of use in relation to sales of office space and also the extent of marketing and advertising throughout the period. She did not dismiss or ignore the advertising and marketing use. On the contrary, 267 and 269, specific regard to the positive evidence and lack of evidence of further marketing was a proper holistic analysis. She had regard to all this marketing use and considered it desultory, having regard to the market and indeed EasyGroup's previous marketing in 2007. That finding of desultoriness wasn't a finding of simply to quantum, but it was made in relation to firstly the type of advertising, the nature and the form of the advertising, the dates and duration of the advertising, and importantly the effectiveness of the advertising, when there's no attempt to do anything else, when the results of the original adverts, the flyers, for example, in a period outside the relevant time period, resulted in no further office take-up. She was entitled, therefore, to come to that conclusion, and desultory is not evidence of her using a de minimis test or just considering the quantum alone. Therefore, this leads me to the next point, prison made by my lone friend, that somehow EasyGroup is being penalised because the judge took regard of what EasyGroup had done before. Well, that's what Little says she should do in terms of having regard to the marketing and other characteristic capacities of that trading entity. Can't be wrong as an area of law or principle when what she's following is the guidelines of Little in paragraph 31, and nor as a matter of fact should it be wrong. Just stand back and ask yourself whether or not this is a fact to take into account when you're considering whether there's genuine use or real use by a proprietor. Is it really the case that a proprietor who has a tiny business, tiny assets, tiny financial flow, that factor shouldn't take into account whether it's marketing genuinely or whether it's making sales generally, as opposed to a large, sophisticated, well-established business there's a very sophisticated advertising marketing team, has made numerous sales and provided services on a large scale before, and then you compare with the evidence they leave before this court. It offends against first principles, let alone the law, which it says you have to take into account. And then, insofar as Arnold continues with his suggestion that the judge failed to mosaic all these points together, as I've shown you, she did take all relevant considerations together in relation to Croydon and rejected that EasyGroup's contentions were sufficient to establish genuine use. We say that's no other principle on some issues entitled to do. If we write about a construction issue, she is also right as a matter of law to separate out the nature of use in relation to Croydon and instant offices, because they are used in relation to different services. Even if the construction issue is wrong, all EasyGroup submissions really map to is mosaicing at heart that the total use should be considered better than the sum of its parts when it's inadequate on both bases. Now, it is fair that in the judgment itself, I don't believe there is an express paragraph where the judge says specifically she is combining Croydon use and instant office use and assessed as a whole, but it's unfair, again, unfair to the judge to be criticised on that way, given that that was the primary case, that was the way in which the case was primarily put before her by the other side. They were saying there are two types of use which have to be considered separately, both pleadings and factual evidence, and also the oral submissions which I've shown you. That section of the transcript I've shown you, the judge said, and do I take into account instant offices? And she was told, no, we'll come back to that. And then Mr. Manager came back to it and dealt with instant offices separately. We do say if it's not adequate for each type of use, two types of use together are similarly inadequate. Orally, no submission to put the two together. On the contrary, she was told to mosaic separately for each of them. It is true that after the trial, EasyGroup submitted a supplemental closing submission, and for your note, that's in SB1, tab 11, at page 112, and that addressed, so far as we're aware, for the first and only time at paragraph 9, that when seeking to prove genuine use of EasyOffice Croydon, the court should take into account as to whether or not there's been genuine use of EasyOffice mark in relation to instant offices. Now, as I said, as a matter of logic and fact, we say that's not appropriate anyway. As to the instant offices evidence, the judge held that the instant office evidence of use was insufficient and inadequate to establish genuine use. And she was right to do that. And start at 273 if we can, please, because again, this puts in context what she found about instant offices as opposed to the way in which the website operated. There's no clear and consistent evidence as to how the partnership with instant offices worked in practice in terms of customer booking experience. EasyGroup's opening submissions and Stelios's witness statement suggested bookings were made by EasyOffice through the easyoffice.co.uk website rather than by instant offices. That was not, however, consistent with the evidence of Mr. Richardson, who was involved in the website design before he left the company in 2011, and who said that instant offices had provided a booking engine for serviced office space through its sub-site, book.easyoffice.co.uk, and that had provided instant offices with EasyOffice branding in the form of imagery which sat upon the instant office's booking engine. The imagery took the form of the following logo. Now, and 274, you'll see there's no solid evidence.
Can you enlighten me?
Yes.
Why does the inconsistency matter, given that both versions involve use of the trademark?
Well, both, nonetheless. Firstly, the first version wasn't established on the evidence, and therefore is not a finding of fact.
Fine. So if we assume that the judge accepted the evidence of Mr. Richardson,
which was,
I think that's a very reasonable assumption.
Absolutely, which was that prior to development date, all he had given was logo in this form, which is not actually the logo, the registered logo, to instant office.
But would you dispute that's use of the word mark?
No, I wouldn't dispute use of the word mark.
And it's also use of the camel mark?
It's not identical, it's similar to both.
You dispute that's use of the camel mark?
I don't need to go there. I'm happy to accept for the purpose of this submission that it's use.
Right.
If it had been used in relation to services. But what you don't have, so you have, what you don't have is evidence then of what actually happened during the relevant period with that mark. And the judge made quite clear in 274, neither Sir Stelios nor Richardson were able to give any evidence to how the bookings were made by customers and how, if at all, the Easy mark was used to identify EasyOffice as a source of services in the booking process. The only evidence that shed any light on this was the historic website screenshots pages from book.easyoffice.co.uk site, not the website that my learned friend keeps banding around, taken from the Internet Archive Wayback Machine. These show that the website page on which the above logo was placed did not allow booking by customers. Rather, customers could only request a viewing of the office sites returned by the booking engine or call a telephone number that was operated by instant offices, not EasyOffice. As Mr. Richardson confirmed, EasyGroup did not have a call centre at the time, would have been able to respond to such calls. So, just pausing there, at best, the evidence appeared to indicate that insofar as there was any logo use, it was using it as some sort of referral to instant offices, in respect to which there was no evidence as to how the instant offices website and booking process worked. That was the evidence that the judge was given in relation to instant offices. And it's why I am able to say, as I did earlier this morning, that when you look at the easyoffice.co.uk website, you are not seeing instant office's use of the mark. You're not. You're seeing at best the initial direction or directory or first portal to send the customer off to instant offices. So that's why I do say, at best, on the evidence before her, she had the EasyOffice mark being used as a referral to instant offices, and then she had an absence of cogent evidence as to what then happened. My learned junior points out that the sub-site is a separate website which looked at and functioned distinctly, and that you can see in the exhibit to Mr. Smith, SP2 tab 23 248. But actually, I don't think you need to go there because the judge has clearly pointed out that whatever happens is she didn't have evidence to work out what was going on that website. Then at 275, she says, I've given no solid evidence of what, if any, revenue was generated by the partnership agreement arrangement. Figures and documents were unreliable, and no witness to explain what they referred to, even less the mark in the relevant territories. Well, we've got that issue about whether it's worldwide business and so forth, but I can put that second point behind. Third point, and ignore the third point against myself on the basis of my learned friend next submission, whatever use, it must have been used within the UK. Well, that doesn't necessarily follow. But in any event, the first 2 points are absolutely solid. No solid evidence of any revenue generated by the partnership agreement, because she's already found, rightly, that the figures and documents were unreliable, and there's no witness to explain how they were created or what they referred to. Even less the use of the mark in relation to those. 278, no solid evidence that the revenues were generated by easyoffice.co.uk or the separate sub-site. All we had in relation to the sub-site, as I've indicated, was the hearsay notice of in relation to Mark Smith's 2 witness statements from 2007 and 2009. Judgment at 280, no clear evidence of the use of the trademark in the transaction process at all. And at 282, no solid and objective evidence at all of the nature of the use of the trademark or extent of trade generated on the basis of the mark. Now, in our respectful submission, therefore, she hasn't left anything out of that analysis. She's entitled to come to all those findings, and she's not in any way evidencing an error of principle. Those were findings of fact she was entitled to come to on materials before. There seems to be some floating suggestion that nonetheless the judgment should be criticised because she should have found there must have been some business. Well, whether or not there was some business is not good enough to establish genuine use. What we didn't have is proof of evidence of use of the mark in relation to the registered services. At best, I say, we've got a referral to a referral site. I've already shown you no bookings, no call centre, and 280, the inadequate evidence as to the easy mark was actually used in relation to. No evidence as to the traffic to the website, compared with what I showed you in relation to 2007, the evidence of Mr. Smith, where he gave page views. The fact that invoices were submitted is accepted by the judge, but that doesn't take it any further, because she had no material to determine what those invoices were in fact for, or what referrals were made. No disclosure of the partnership agreement, as despite them being positively pushed for that in the request for further information. And no witnesses were called to give any evidence about the partnership relationship with incident officers, even though we obviously know that Mr. Smith was potentially available. Mr. Richardson was no longer an employee, but he came along and gave evidence, wasn't able to give any evidence in relation to the commercial relationship, and had left before the relevant period. So, in our respectful submission, the judge was right to conclude that the evidence before her was not solid and objective evidence of actual and sufficient use on the market concerned, but was rather gaping with holes, and was requiring her to make a whole series of probabilities and suppositions as to what actually was going on. Yes, now I should also point out to make good in terms of the partnership. She was, and the judge was rightly critical and surprised that there's no evidence in relation to it, given in 281. The agreement with the company continued until January 2019, only a few months before the present proceedings commenced. There's nothing in the material before me to indicate that it would have been impossible for EasyGroup to provide further evidence from these or other sources.
Can you enlighten me? I mean, I'm not in any way questioning what the judge has said, but just says for our fuller understanding.
Of course.
How was the judge able to make a finding that the agreement with the company continued until January 2019, when she'd earlier said there was no evidence about any agreement at all?
That's the pleaded case, I think, in the further information, my lord. That's what the asserted.
So when she says, given the agreement with that company continued, what she meant was alleged to have
alleged to continue, as said, that in the further information.
Yeah. Okay, thank you.
And my junior is very differently says that's stated in page 374 of the core bundle. For completeness, the claimant ended its relationship with incident officers as from the 31st of January 2019. Thereafter, was continued to offer its own service to officers, it temporarily ceased using brokerage services. So we do say, in summary, at the end of the day, the only evidence in relation to incident officers in terms of really that was before the court in the relevant periods were extracts from various sub-sites, book.easyoffice.co.uk, and some invoices. And the judge was not persuaded that the nature or extent of this arrangement had been sufficiently evidenced, and there was not enough solid and objective evidence to establish genuine use. And we say that that is something she was perfectly entitled to come to on the materials before her. Now, just a few wrap-up points on use, if I may, in terms of advertising use, if I haven't already addressed them. I've already shown you judgment 26. I've already shown you how she refers to both the flyers, Google AdWords, MailShot, and EasyOffice website, wanting to count. I've addressed desultory. Easy.com portal use. As I understand my learned transmissions yesterday, is no longer relying on that. And therefore I don't need to address you, but if you feel you need any addressing on that, I would and will do so now. And obviously the simple point, as my learned friend quite rightly accepted, was that it wasn't used in relation to any services. It's just simply a list of their domains. And as we set out in our submissions, the evidence that it's not being used in relation to any services, amongst other things, is that it lists easy everything, which on the evidence before the court, the judge found was the business went wound down by 2007, and there's no evidence that easy everything mark has ever been used thereafter. As to the advertising use being desultory or minimal, I've addressed the fact that it wasn't limited to an assessment of just quantum. It was, on the contrary, dealing with both the type, nature, form, dates, duration, and the efficacy and effectiveness, and the fact no attempt was to do anything afterwards. And that, in light of all of that, she was entitled to find, as a matter of fact, and judgment, that the advertising use was desultory and minimal. My learned friends make a suggestion which I didn't canvass orally in relation to easy office space, which the judge refers to in her judgment at 279 to 80. It makes some sort of suggestion that by referring to this proceedings, the judge was relying on use by a different mark with different evidence. What the judgment makes clear at paragraphs 279 and 280 is that she doesn't rely on factual findings in relation to the easy office space case, but is considering the analogous submission that EasyGroup produced insufficient evidence of the extent of use of the mark in question, specifically as to the weight which could be given to the images of the mark on websites in circumstances where there's no information about the volume and frequency or transactions that were generated. Both the EUIPO and the Judge of rightly held that mere presence of the trademark on an image of websites has nothing about extent of use of the mark, and she was entitled to observe that EasyGroup's evidence was similarly lacking and insufficient in this case. The judge went further here because there was no clear evidence as to the nature of the Easy Office trademark in the transaction process at all when considering the incident officer's arrangement. And it's not as if the Easy Office space decision is in any way unconventional. Could I ask you to look at the authorities bundle, please, tab number 6, tab 76. These are the EUIPO guidelines, and if you're would be so kind as to turn to page 1786, section 6.1.2.6, use on the internet. The standard applied when assessing evidence in the form of printouts from the internet is no stricter than when evaluating other forms of evidence. Consequently, the presence...
I'm sorry, I'm on the wrong page. No,
One
I've got that, thank you.
1786,
Yeah.
Section 6.1.2.6. Consequently, the presence of the trademark on websites can show inter alia the nature of its use or the fact that products or services bearing the mark have been offered to the public. However, the mere presence of a trademark on a website is of itself not sufficient to prove genuine use unless the website also shows the place, time and extent of use, or unless this information is otherwise provided. And then below the table, in particular, the value in terms of evidence of internet extracts can be strengthened by submitting evidence that a specific website has been visited, and in particular that orders for relevant goods and services have been made through the website by a certain number of customers in the relevant period. For instance, useful evidence in this regard could be records that are generally kept when operating a business web page. For example, records relating to the number of hits attained at the various points in time, or in some cases the countries from which the web page has been accessed. And then over the page, after the third bullet, 1787, the evidence submitted must show that the online transactions were connected with the goods or services designated by the mark. This is all conventional stuff that EasyGroup knows inside out. And it's what it tried to do much more successfully in 2007 and 2009 when it's submitting the evidence to Mr. Smith, and totally failed to do it in this case altogether. The judge was entitled, therefore, to draw from that absence of evidence. But the absence of evidence as one of the factors when she was considering the genuineness of the use as one of the factors to take into account. So, in summary, in relation to revocation, no ever principle applied the correct law and applied it to the relevant material facts which she was entitled to find. That's everything on revocation.
Very good. Mr. Malinich, I don't think there's any point you starting your reply now. But first of all, could you give us an estimate as to how long you will be in reply? And could we then just have a brief word about timing going forward if we get to that?
Probably do both topics in an hour. Probably limit myself to an hour.
Seems quite long for a reply.
In that case, I shall limit it to 45 minutes.
Well, look, Mr. Malinich, I'm not guillotining you.
Yeah.
You will take as much time as you feel you need, but it is a reply.
Understood.
Now, let us assume that you do need an hour to reply and use an hour, and let us also assume, just for the moment, that we carry on to hear the remaining parts of the case. Will that allow sufficient time, the remaining parts of the case, to be argued by close of play on Thursday?
I think we're not in trouble on time, my Lord. I think it won't affect it one way or another. We were looking at various matters this morning, and Miller and Friends being quicker today than I think he said he would be. We thought we might be later in the afternoon, so we're making good progress. That's all I can.
All right. Now, while we're on the subject, can I just be clear that I understand the relationship between the different parts of the case? Mr. Van Heegen, as I understand it, your respondent's notice falls, as it were, into two parts. There are parts of the respondent's notice, and I know you've dropped some small points, which reduces it slightly. But broadly speaking, you've got two types of respondent's notice. Some points where you're putting forward additional grounds to support the judge's conclusion. But then you've also got respondent's notice points which amount to cross appeals. But as I understand it, the cross appeals are only advanced contingently if the appeal is successful in some material respect.
Yeah.
So if the appeal were to be dismissed, therefore, it would follow, as I understand it, that this court would not need to consider any of the respondent's notice points. Is that correct?
Any of the contingent response notice points. If the appeal
is dismissed, then
at this stage, you don't even need to consider a response notice which is not contingent. Absolutely.
Yeah.
And what I was going to in terms of a roadmap, what I was intending to do, if the appeal were not to be dismissed, the next logical topic that I was going to address was the consent point on our classic response notice.
Because that's an additional ground for reaching a conclusion of non-infringement. Yes,
Which
understood.
is what I was hoping to do today if we needed to do it. But thereafter, although there are formal points which are additional grounds, such as Marusha and non-defence, non-use as defence, those are better characterised as being ancillary issues, which I was going to do in any event after the contingent part.
All right, that's helpful. Thank you very much. We'll resume at 2 o'clock.